NACDL is the association of the nation's criminal defense bar.
We are going to start the discussion with sort of the debate that you may have heard as to whether cross-examination is a science or whether it's an art. Spoiler alert, I think it's a scientific art. We'll talk about that. We'll talk about the steps that I would suggest that you take in preparing and executing your cross-examination, and then we will end with a few additional practice tips. I don't mean to stand on stage for the next 40 minutes or so and just bark at you. And so if you have questions, concerns, disagreements, please chime in at any time. I would welcome the feedback. I think that's how we all get sharper. So please chime in if you have any questions or concerns or disagreements. So cross-examination, I have been around a lot of academics, and I've heard many academics say some variation of, well, cross-examination is really a science because there are tried and true methods of preparing and executing a cross. And if you follow those tried and true methods, you will have a successful cross. So everyone should do the same thing. I've also been around some very successful practitioners that will say, I totally disagree. Cross-examination is an art form. We're all very different people, and so cross-examination is inherently different from lawyer to lawyer because we all have different personalities. And I personally think that there's some truth to both of those statements. One thing that I have also heard that I don't think is true, I've heard people say, good cross-examiners are born with it. I was just born to be a cross-examiner. That is not true. There is no one, no matter how talented you may be, you were not born to cross-examine. I think it's a scientific art. And I wish I could say that I came up with this myself, but I stole this from Posner and Dodd, and that is that trial lawyers free the talent from within by applying the scientific approach to cross-examination. In other words, if you actually follow the science, if you follow the tried and true methods of preparing and executing your cross, then your personal sort of personality, your uniqueness will shine. So I encourage you to do both. Follow the tried and true methods, trust the science, and then your personality, your unique personality will shine. And I will say this, good lawyers borrow all the time. Great lawyers steal, and the overwhelming majority of what I'm going to tell you today, I have stolen from I've stolen from other trial lawyers much more talented than me. And so I wish I could say I came up with all of this. I did not. I just put it all in one place. Now, the first step to crafting a successful cross-examination is making sure that you have a theory of the case. Step one. Now, a theory of the case is just a concise statement that justifies why your client is not guilty. I often say, if you can't explain your theory of the case to a layperson, to a non-lawyer, you don't have a theory of the case. The way I test it, is, I'm not sure if this is the best way to test my theories, but usually I find myself in a barbershop before trial, and I tell my barber my theory of the case. And if I can't articulate to him what my theory is, I don't have a theory. Cross-examination simply provides you an opportunity to advance your theory of the case. So you must have a theory before even drafting your cross-examination. And after you have, one other thing a couple other things I should point out, excuse me. When you're crossing a witness, you can do a few things. You can be highlighting helpful facts. You can attack the witness's credibility. You can debunk harmful facts. You can do all of the above and not necessarily in that order. But one of the most powerful cross-examinations I have ever seen is when a lawyer confidently stands up looks the judge in the eye and says, "No questions, Your Honor. No questions." The only reason you that you cross a witness is to advance your theory. Do not do what I've seen some other lawyers do, which, I'm not sure where they teach this, but I've seen it in various states and in various courthouses. People will stand up and sarcastically repeat the direct as if it is making a point to the jury. "So you claim that you saw him with the gun?" Yes. Right? It doesn't work. Doesn't work. So don't just stand up and repeat bad facts. It is okay. It shows confidence in your case when you stand up and say, "No questions, Your Honor." After you have a theory of the case, I would encourage you to then have a theory of the particular witness. How does the witness advance your theory of the case? Is the witness mistaken? Is the witness lying, biased, just unreliable, or some combination of all of them? And now that you have your theory of the case, your theory of the witness, now it's time to begin drafting your chapters. You may have heard of the chapter method of cross-examination. I live by this method. I wish I can say I created it. I'm going to say it again. This came from Posner and Dodd. A chapter is one discrete point that supports your theory of the case. That's a chapter. Just one point. I always begin drafting cross by it's like a brain dump. I just list every conceivable chapter I can come up with, just listing them all out, just getting out every conceivable chapter that could possibly help my theory of the case. So one example of a chapter is, there's a reason to doubt Michael's testimony because he was intoxicated when he saw the exchange. That's one example of one chapter. And I will actually write it out this way, word for word, when I'm drafting my cross. And that is for a few reasons. One, writing it out is going to help you organize your closing argument. It may seem like overkill, but if you just have a whole list of reasons to doubt, that starts to sound like a closing argument, right? And it helps you. Now you have this entire long list of reasons to doubt. And when you start drafting your closing, it'll make it that much easier because you have all of your reasons to doubt listed out. I literally write it out this way. I will highlight a particular word on every single chapter. So this particular chapter relates to intoxication. So when I'm looking at my notes, I can just glance at my notes. I see the highlighted word intoxication. Now I know where I'm going, and I'm less reliant on my notes at this point because I've seen that one highlighted word on the page. So that's a practice tip I would encourage you to consider if it works for your practice or not. So now you've got your theory of the case, you've got your theory of the witness, you've listed every conceivable chapter out there. Now it's time to start writing your questions. So this is the chapter method of cross-examination, that is asking a series of questions to establish one discrete point. The discrete point is the chapter, but you're going to ask a series of questions to establish that discrete point. And every one of your questions, I would encourage you, I would say, I try not to speak in absolute, so I didn't write 100%, so I got as close to 100% as I could. I would say 99% of the questions that you ask should be leading questions only. There is I've seen a whole presentation on advanced cross-examination, and that presentation was phenomenal. I walked away inspired. But I will tell you, I have never, ever asked a witness on cross-examination a question that starts with who, what, when, where, how, describe, or explain. That's because I'm a control freak. I would rather control the cross-examination, and you lose total control when you ask an open-ended question. Cross-examination, also opening statements. Those are two places where you have the most ability to be in control. There's always going to be surprises, but you have such an ability to be prepared and to control this part of the trial. I would encourage you to take advantage of it. And I would encourage you to use leading questions only. Now, the phrase leading question is kind of misleading because a leading question is not necessarily a question. It's really just a factual statement where you make it sound like a question at the very end with your voice inflection. It's just a factual statement. I would also encourage you to delete the word remember from your vocabulary on cross-examination. Just delete it. Don't even use the word remember or recall at all. The only time you use it is if you want the witness to say, I don't remember. I guarantee you, if you're crossing a hostile witness or some witness that is not actually helpful to your case, and you ask them, do you remember X? The answer is going to be some variation of, I don't remember, right? So don't ask it unless you actually want the witness to say, I don't remember. And practice tip, if you find yourself on cross and some witness says, I don't remember, it's okay. It's advisable to proceed directly to impeachment. There's no rule that says you must refresh a witness's recollection. You can if you want to, but you shouldn't. Just impeach the witness. You have the right to impeach the witness. Do it. Just impeach them. If the witness says, I don't remember, just go directly to impeachment. Now if you forget this discussion, I hope that you remember this YouTube clip because this will show you that anytime you use the word remember, your witness will likely say, I don't remember.
We don't hire them.
Do you recall that any criminal actions were pending against you at the end of 2008?
I don't recall any.
Do you recall being at all concerned about any criminal actions that may have been pending against you at the end of 2008?
I don't recall.
Do you recall that in the summer of 2007 you were arrested in New York City following a performance at the Beacon Theater?
I don't recall that.
Do you recall that police in New York City discovered a .40 caliber pistol on you, on your person?
I don't recall that neither.
Do you recall that in late 2009 you pleaded guilty to attempted criminal possession of a weapon?
I don't recall that neither.
Did you serve any time in jail following the end of 2009?
I don't know.
Didn't you serve about 8 months at Rikers Island in 2010?
I don't know.
Do you remember being arrested in or about January 2008 near Yuma, Arizona?
No, I don't remember that.
Do you remember being charged in early 2008 with possession of narcotics for sale, possession of dangerous drugs, misconduct involving weapons, and possession of drug paraphernalia?
No, I don't recall that.
Well, how much longer is this line of questioning going to go on?
Not much longer.
All right, go ahead.
I don't know.
Didn't you win
I don't know.
the award for Best Rap Album of the Year in 2008 for the Carter 3?
I don't know.
Mr. Carter, you have to wait until the attorney is finished asking the question, please.
I'm sorry, that's my psychic. I'm sorry.
How would you describe...
All right. So,
We don't hire
so the
them.
takeaway
Do you recall-
is don't use the word remember or recall unless you want the witness to say, I don't recall. All right. When you're structuring your questions, one new fact per question. That's for a few different reasons. One, it's easier for your jury to follow you if you're only introducing one new fact per question. It's just easier to follow. Also, it avoids the annoying objection, compound question. Also, if you ask multiple facts in one question, you don't know what part the witness is saying yes and no to. So you were driving on Fort Street and the light was green. Yes. But is it yes, you were driving on Fort Street, or yes, the light was green, right? So ask one new fact per question. You were driving on Fort Street. The light was green when you were driving on Fort Street, right? One new fact per question. So we mentioned that leading questions are factual statements, but there's a meaningful distinction between a conclusion and a factual statement. So conclusions are generally debatable, right? Those are usually closer to opinions. Facts are not debatable. Do not ask the conclusion, because the conclusion will usually get you a bad answer. Ask a fact only. Leave the conclusions for closing argument. In other words, show, don't tell. So here's an example. The theory of the case is there's a reason to doubt Marie's testimony because she was intoxicated when she saw the exchange. Now, this, at the risk of stating the obvious, you're never going to ask that question, right? That is the chapter. That's what you're trying to prove. But you're going to ask a series of questions to show that Marie was intoxicated, so there's a reason to doubt her testimony when she saw that exchange. So a series of questions could look something like this. The exchange happened at midnight. Now, pause. That's a fact, right? That's not a conclusion. That's a fact. It happened at midnight. You had just walked out of the South Philly Bar and Grill when you claim you saw the exchange. Now, who knows what the witness is going to say? Yeah, maybe yay, maybe nay, but most likely yes. I didn't claim I saw the exchange. I saw the exchange. All right. South Philly Bar and Grill, that's a bar. Yes. You were at the bar for 2 hours. Again, facts. You drank alcohol during those 2 hours. You drank a drink called a Long Island iced tea. A Long Island iced tea contains vodka. It also contains rum. It also contains tequila and gin and triple sec. There are 5 different types of alcohol in one Long Island. You drank 3 Long Islands. You drank 3 Long Islands, each of which contain 5 different types of alcohol. So what you're not going to do is you're not going to say, you were intoxicated, so you couldn't really see the exchange. You're never going to say that because the witness is going to say, I wasn't that intoxicated, and hey, by the way, I did see the exchange. So you want to show in some way that the witness was intoxicated. So all those questions that I just put on that last slide, I actually write them out word for word. It may sound like overkill, but that's the way that it helps you prepare to deviate from the script when you're in trial. You don't have to read word for word when you're in trial. You don't have to read your cross. I would encourage you not to do so. But if you've written out every single question, it enables you to show your personality more. Now you're prepared. Now you can deviate if need be. I have seen some super talented lawyers that have been practicing. One of my old partners, Billy Murphy, has practiced. He's in his late 70s now. This guy still writes out his questions word for word, every single question. And he's 77 years old. He's been doing it for over 40 years. Doesn't matter how long you've been practicing. Doesn't matter how good at this you really are. I would encourage you to write them out word for word. Another tip is that when you're writing out your questions, put each chapter on a different page. Because I guarantee you, on direct, something's going to happen that you didn't expect. And when the unexpected happens, usually you want to tweak your cross. Maybe you want to write a new question somewhere. Maybe you want to reorganize the cross and start somewhere different or end somewhere different. And it's easier to reorganize your cross when each chapter is on a different page. It's also easier to find a particular point when each chapter is on a different page. So I would encourage you to write your chapters on different pages. It's also easier to not rely on your notes that way. Another tip when you're drafting and writing out your questions, avoid wasted words. And we've all heard them. Many of us heard them in law school. Many of us hear them from very talented lawyers. But they're wasted words. So an example is, you drank a Long Island iced tea. Isn't that true? Or isn't it true that you drank a Long Island iced tea? The isn't it true part, it's unnecessary. The question is, you drank a Long Island iced tea. It's also more powerful and more direct when you're not ending the phrase or starting the sentence with, isn't it correct or isn't it true? We're going to talk about primacy and recency in a few minutes, but the same principle applies. And that primacy and recency essentially means people remember best what they hear at the beginning and what they hear at the end. And so that also matters when you're structuring your sentences. And so people are listening to what you say at the beginning and end of a sentence. So don't waste that real estate. Don't waste that space with phrases like, isn't it true? But of course, just like everything in law, there is an exception. And the exception to this general principle is if you're trying to make a particular point, or if you're setting up an impeachment. So you drank a Long Island iced tea. That sounds pretty strong. Or the fact is you drank a Long Island iced tea. There is not wasted words because now you know you're about to impeach this witness. You're signaling that there's something different about this question. So you're starting it differently. The fact is, or it is a fact that you drank a Long Island iced tea. And you're saying that while you're reaching for your grand jury transcript. Right? You are showing that there is something unique about this particular question. When you're drafting your questions, source. Yes, sir. And so that's an excellent point. I'm sure that many of us in the room have been there. A judge is saying, Mr. Downs, that's not a question. Or is that a question? So the question is, you drank a Long Island iced tea. Mr. Downs, is that a question? The first thing I would say is, yes, Your Honor, it is a question. The witness can say yes or no, right? If the judge still requires you, you got to know your audience. If you're in a courtroom where your judge forces you to put the word correct or true, accurate, then you got to do it. But don't make your default. Don't start I wouldn't start every trial with, isn't it true? Blah, blah, blah. Because many of those we have those same judges in DC, we have them in Maryland, and one of them is my friend, and I see him on a consistent basis. He gives me a hard time every time I see him, but we're friends. And he tells me the same thing, you're not really asking questions. He sees me give this same lecture. I do this at a school, and he sees me teach students. And every time he chimes in and says, that's not a question. And I say, yeah, but the default should be when you go into court, start off swinging for the fences. You drank a Long Island iced tea. Start off that way. And if the judge forces you to use a crutch, use your crutch, right? Don't get slammed unnecessarily too many times in front of your jury. So then you got to use your crutch and make them as limited as possible. You drank a Long Island iced tea, correct? You drank 3 Long Island iced teas, correct? Right? And so that's the way I would do it. That's exactly what I do. And I've seen it happen a lot. It's an excellent question. Thank you for bringing it up. So every time you're drafting your questions, source every single question. Came from grand jury, page 30, lines 11 through 12. Now, you never know when you're going to need to impeach a witness. And so if you don't have the source next to every question, you won't get caught. The witness is going to spin you. The witness may actually truly just forget, right? The witness may forget some basic foundational thing that you thought was easy. Right? You were at the South Philly Bar and Grill on August 15th. I don't know what the bar was called. And this is a great opportunity for you to establish that you are in control, that if you say something, it is accurate, right? So if the witness doesn't remember or forget some innocuous detail and you have the source, you impeach the witness right then and there because it shows that you're in control of this courtroom, and if you ask a question, you already know the answer. So write out every source for every question, because if you don't, I guarantee you the witness will forget something that's small, and then you'll be fumbling through your notes trying to look for the impeachment. The most common form of an impeachment is an impeachment via inconsistent statement. That's the fun impeachment. That's the one that we all know and love. There are other forms of impeachment. Impeachment via omission is another form. There are others that we won't talk through all of them today. Inconsistency with another witness. That actually happens more than you think, so we'll touch on it. Impeachment via bias, impeachment via prior conviction. We won't discuss today, but I didn't want to talk about impeachment without flagging for you that there are various forms of impeachment. They're all on this screen right here, on this particular slide. So if you're impeaching via inconsistent statement, I would encourage you to write out the impeachments that you hope happen or that you think are going to happen, right? Write them out, word for word. It'll prepare you. The reality is you really can't be prepared for every impeachment because the witness will forget something or say something inaccurate. That's why you have to source every single question. So how do you do an impeachment via an inconsistent statement? The 3 steps. First, you confirm. Second, you confront. Third, you complete. Confirm, confront, complete. Those are the steps. They're actually very simple, but those are the 3 steps to completing an impeachment, or to conducting an impeachment, excuse me. Confirming is exactly what it sounds like. You are confirming, you are establishing the current version of the testimony to be impeached. When you're confirming, I would encourage you to use body language or actual language to signal that an impeachment is coming. Today, you claim that you drank 2 Long Island iced teas. Or your most recent story is you drank 2 Long Island iced teas. Or it's your testimony today that you drank 3 Long Island or 2 Long Island iced teas. Use some words, some body language, some language to show your fact finder something's about to happen. What's about to happen here? When you're confirming, I would encourage you to use the language that is the closest as you possibly can to the prior inconsistent statement that you have. So you've got a statement that says, at 4 p.m., the light was green. You have that in a transcript somewhere, in a defense statement, in a grand jury statement. You have 4 p.m., the light was green. So I would encourage you to confirm using the language closest to that as you possibly can. Your most recent story, so you're signaling to the jury something is coming. Your most recent story is at 4 p.m., the light was not green. So now you're confirming what the witness is claiming. You're confirming the most recent testimony. Now you're confronting the witness with the prior inconsistent statement. And the method through which you do that depends, right? What are you trying to accomplish by impeaching this witness? Are you saying that the earlier version was true? Or are you saying the witness is just inconsistent and therefore unreliable? Neither version is true. The witness is just not accurate. What are you trying to prove? You have to know that before you start impeaching the witness. The first version was true, or neither is true if the witness is just inconsistent and therefore lying. The method through which you confront the witness will depend on what you're trying to prove. So here, in the first example, you're trying to establish that the earlier version was true. So here, I would encourage you to lay a foundation as to all the indicia of truth, right? Who was there when it happened? The prior statement happened closer in time than we are today in court. The prior statement was under oath, maybe it was signed. Build up everything that shows that prior statement was true. Practice tip. You may get some prosecutor, if you impeach, and then you stand up in closing argument and try to use that impeachment to say that the prior version was true, you may get some prosecutor that stands up and says, objection, that impeachment was not for the truth of the matter. There's nothing to say that prior version was true, judge. So the defense counsel was arguing improperly. So if you want to argue that the prior statement was true, I would encourage you to ask the question, what you said in January, that was true, right? When you were talking to the grand jury, you answered questions, yes. You answered them completely, yes. Accurately, yes. Truthfully, yes. And the truth that you gave in January of 2021, that's still true today, right? Yes. And then you go and impeach. So now when you're in closing argument, you can argue the truth of the prior statement. Because if you don't, you may get some prosecutor that stops your closing argument and says, counsel was arguing improperly, arguing the truth of the matter. That was an out-of-court hearsay statement that was not admitted for the truth. So that's a tip that I would encourage you to incorporate or at least think through whether it works for your practice.
The CLE verification code for this program is A9A721. A9A721.
So now you're confronting the witness saying, neither version is true. How do you do that? Very similar, but you just leave out all the indicia of truth. There's no need to prove or to say, well, what you said in January was under oath and it was truthful then, and that truth hasn't changed today. You can leave all of that out. You can skip right. You can lay a foundation. You were in the grand jury, you answer questions, but you don't have to describe how truthful those answers were. And the tone of your voice and your body language is more accusatory. I will tell you, I have a big problem, as you may have seen over the last couple of minutes. I talk with my hands a lot. So I have to tell myself, put your hands to your side, because otherwise I'm just going to be flailing all over the place. So I do tell myself when I'm impeaching a witness, if I want to come across as more accusatory, then I use my hands in a more accusatory way. And so I may say, the light was green, right? Or the truth is the light was green. If I'm confronting the witness and I think the witness is just mistaken or I don't necessarily want to come across as accusatory, maybe it's a child witness, then I often do things and put my palms up. So the light was green. Right? I mean, the truth is light was green. Right? I come across less accusatory when I'm asking. I mean, truth is you drank 3 Long Island iced teas. Right? But the truth is, you drank 3 Long Island iced teas. Very, very different body language, right? And so when you're confronting a witness, think through how you're going to use your hands, your tone of voice, your voice inflection. All of that depends on what you're trying to prove. Now you're completing the impeachment. So you've confirmed the version to be impeached. You have confronted the witness, and now you are completing the impeachment. You read this statement word for word. There's a lot in that. So let me start off. Why do I say you read it? Because if you give it to the witness and allow the witness to read the grand jury transcript, I guarantee you the witness will not emphasize the part of the testimony that you want the witness to emphasize. They're going to gloss over it. They're going to read it really quickly. Or worse yet, they're going to read something else that hurts your case, right? They're going to read a line that you're not even pointing them to. So, Mr. Downs, I'm going to ask you to read lines 13 through 15 to the members of the jury. And that witness is going to start at line 3 and read all the way down to line 21, right? So do not give up that power. You read it, and read it word for word. The worst that can happen is that you're in the middle, you're flowing, you're kicking butt, and you're impeaching your witness, and you miss a couple of words, and a prosecutor jumps up, objection, counsel didn't even read the entire statement, Your Honor. It comes across as you're misleading the jury. So don't paraphrase. This is not the time for paraphrasing. Read it word for word. And I like to read it slowly. That's maybe a little bit too dramatic, but I would encourage you to read it a bit slowly to make sure that your fact finder is listening and hearing everything that you're saying. If you're completing the impeachment by another witness, make sure that you ask the witness on the stand the same question you plan to ask the other witness. The truth is, you drank 3 Long Island iced teas. No, I didn't. Just move on. Move on. Go to your next question. And now, just don't forget to call your other witness. Right? Call the other witness, bring that witness on the stand, and you ask the same question. Mrs. Lawson, the truth is, Jason drank 3 Long Island iced teas. Yes. Right? So now you're completing your impeachment by another witness. When you're impeaching via omission, a little bit harder, but not nearly as hard as people make it out to seem. You can impeach by saying, you never said the light was red. Or another, read this document and look up and tell me where it says the light is red. Or, I'm going to give you this red pen. Circle in the grand jury transcript where you said the light was red. Those are different ways to complete an impeachment by omission. When you're doing this, though, you do need to, when you're doing this being an impeachment via omission, you need to establish a few things. First, that the witness understood the need to be complete when he or she gave this important testimony before or story before. That the document, the report, the transcript, the grand jury transcript, that was an appropriate place or the appropriate place to make this statement, and the witness knew this information at the time. Now, all of that sounds fairly detailed. I'm going to give you a practical matter as a practical tip here. If you're impeaching by omission in criminal cases, usually you're using a grand jury transcript or a defense statement. Usually. Of course, there are variations. Maybe you're using some kind of recording. But usually it's a grand jury transcript or a defense statement. And here, you need to establish that a question was asked that would have elicited that response. Right? So as a practical matter, it is usually, I'm going to turn you to page 33, line 13. You were asked, when you got to the traffic signal, what did you see? And when you were asked that question, circle for me with this red pen where you said the light was green, right? Or the light was red, whatever. That's the way that I would encourage you to do an impeachment via omission. I would usually encourage you to say there was a question that was asked that should have elicited that response. What I don't do is I don't just give a witness a 100-page transcript and say, find it in here. That kind of seems unfair, right? And your judge is probably not going to let you do that. You give the witness some long transcript and says, hey, find in there where it says the light was red. The jury thinks you're being unfair. Your judge is annoyed. Instead of that, point that witness to a particular question where the answer should have been, and in the answer, the light was red. Organization. How do you organize your cross? Now, you've written out your questions. You've written out your chapters. You have now written out all the questions to establish the chapter. How do you organize your cross now that you have everything written out? You want to organize your cross, of course, to maximize the persuasiveness of your cross. We talked about primacy and recency earlier. That is, a listener remembers clearly what they hear at the beginning and at the end. So there are two schools of thought when it comes to how to structure a cross-examination. One school of thought is you start strong and you end strong. The first and last chapters of your cross should be the two strongest chapters that you have. That's one school of thought. And that is because people remember most clearly what they hear at the beginning and at the end. There's another school of thought that says, well, the first chapter of the cross should be less controversial. Ease your way in to the cross-examination. Don't just come out swinging with a baseball bat, right? Every single school of thought that I've heard, every school of thought says you end strongly, right? There's no school of thought that says you end on a weak note. Do not end on a weak note. You end strong. But the question is, do you start strong or do you start kind of easing your way in? I will tell you that my opinion is you start or you end strong with every single chapter, across, no exceptions, every cross you end strong with. But I always start strong unless there's a reason not to. There are reasons, like you've got a vulnerable witness, child witnesses, crying witnesses, mentally handicapped witnesses. That's when I won't necessarily come out with a baseball bat. I will start a little slow and work my way into the cross. But that's the exception to the rule. That's the way I would encourage you to think about it. But no matter what, end strong. Do not end on a weak note. Now we're just going to go through a couple of practice tips before I sit down. First is consider using triples in your cross-examination. Triples are used in so many different aspects of advertising, music, politics, and it's because all of the science says that people remember things in three. It's powerful when you're hearing things in threes. I mean, triples can be incorporated in openings, closings, directs, and cross-examination. An example of a triple, you drank 4 Long Island iced teas. You drank 4 Long Island iced teas before you spoke to the police. You drank 4 Long Island iced teas before you participated in an identification procedure. You drank 4 Long Island iced teas before you tried to identify a suspect, right? So these are all different questions, but you're sort of drumming into the juror's head that this witness drank 4 Long Island iced teas. Of course, just like everything in trial work, try not to overuse this. Looping is another practice tip. And looping simply means you establish a fact and then you use that fact in your next question or your next series of questions. So the man was tall. The tall man was wearing a hoodie. You were never face to face with the tall man wearing a hoodie. Right? So you're just looping in the answers that you got into your next question. Again, don't overuse it. It can get a bit annoying if you do, but it's one tip that I would encourage you to put into your include in practice. This I have to tell myself anytime that I am doing a cross-examination and it starts getting good and it starts getting really fun, then tell yourself, do not ask the one question too many. Right? So now you are slamming this witness. You got the jurors nodding their head. The judge is looking at the witness with disgust. Prosecutors thinking, what the heck happened to my case? And you are thinking it is time to hit the home run. Do not do it. Don't do it. So you're slamming the witness. And then you're ready. And you didn't really see the face of the tall man with the hoodie. Yes, I did. And now you're screwed, right? Right? So you get all this good word 4 Long Island iced teas, dark outside, tall man wearing a hoodie, not face to face. You got all this good stuff out. Then you ask that one question too many, and it undoes everything, all the hard work that you did. Do not ask the one question too many. A good tip that when you're getting too close is when it starts getting real fun. Tell yourself, don't ask that next question. I stole this from Thomas M.L.A. Cross-examination is the art of hitting singles and doubles. The moment that you try to hit a home run, as soon as you try to hit that home run, you will strike out. Singles and doubles. Singles and doubles. That's cross-examination. You are not hitting home runs. Cross-examination should be about you. You should be doing the overwhelming majority of the talking, not the witness. The witness, if you're doing it right, usually the witness is giving very short answers and you're doing all of the talking. Make additional copies of documents that you plan to use, right? One for the witness, one for the judge, one for the prosecutor, and one for your client. It also makes you look more prepared, right? Judges like that. And the jury looks, and the jury knows when you're unprepared. And if you're about to impeach a witness, and so today you claim that you only have 1 Long Island iced tea. You're picking up 4 different documents, handing one to the prosecutor, you're handing one to the judge. You seem like you know everything that's about to happen in that courtroom. So make copies of every document that you may use in court. Technology, I will tell you that I have been in the position where I did not confirm that technology worked. And every time you don't confirm is when it doesn't work. Right? So just confirm it. Go into court early and make sure that whatever video you're trying to use, whatever audio you want to use, it actually works. Because the one time you don't is when you're going to need it to work and it won't. So just go to court a few minutes early. Ask whether your judge will allow you to cross from the well of the courtroom. And so the judges that you described earlier are some of the same judges that tell me, Mr. Downs, cross from the podium. Right? You are not allowed to cross from the well of my courtroom. If you can cross from the well of the courtroom, I would encourage you to do so. Why? Because cross, again, the focus is on you. The witness should be looking at you. The jurors should be looking at you. You're doing most of the talking. The witness is just there to say yay or nay. Right? And so if you can stand in the well of the courtroom, stand there. But you got to know your judges. There are many federal judges that will say, you may not stand in the well of my courtroom. You must stand somewhere within arm's reach of the podium. And so I will literally do stuff like this and just stand like, right here. But the point I'm making is know your courtroom, know your judge, and know whether that judge will allow you to cross from the well of the courtroom. Pay attention to the witness and the witness's answers. So this requires you you can't be glued to your notes. That's why I encourage you to write out your questions word for word, and then you won't have to be glued to your notes. But you need to know the witness's body language. Body language tells you a lot. And so I would encourage you to make sure that you're paying attention to your witness. Themes. Anytime I've seen new and really talented lawyers, they will have a theme in their opening. It'll be creative, catchy. Everyone remembers this great theme that's applicable to the case. But then they don't use it again until closing argument. Right? They have this great theme. They forget to weave it in throughout the course of the trial. Don't forget, if you've got this great creative theme, use it during your cross-examination. Throw a question in there that uses your theme, just so the jury doesn't forget that you promised that this was going to be the theme of this trial, and you're delivering on that promise. Don't just use it in opening and closing. Use your theme on cross as well. This is unique to COVID now. I've seen some bench trials where judges are now sort of either pushing client or pushing defendants to at least allow some witnesses to testify virtually. Make sure that you know the law here. This is, we don't all have to go to court knowing every single, Sixth Amendment case or Fourth Amendment case, but this law, I would encourage you to at least know the test, that when a judge is trying to have a witness testify via video, it's not inherently unconstitutional, but the judge needs to hold an evidentiary hearing and find that a denial of face-to-face cross is necessary to further an important public policy, and that the reliability of the testimony is otherwise ensured. The point is, you should know that there is a hearing that is to be required before a judge makes this determination. I have seen this increasingly in virtual trials. And the very last practice tip I will say is have fun. Have fun it may sound sort of cheeky, but I literally mean that. Cross is more fun when you're prepared. Right? If you walk into court knowing that you've done the work, that you've written out all of your chapters, that you have every single question sourced to every document, it's more fun. Then you can be yourself. But you're much more worried, you're much more nervous if you walk into court unprepared. So do the homework and then go up there and have a ball. Thank you very much.